The group that Ruth Bader Ginsburg worked for was very much a product of the time that they came into existence in. And the fact that this case and the factual setup of this case is the one that really makes it very difficult going forward to have gender-based distinctions in the law is purposeful. This case was chosen for a reason. Just like Brown v. Board of Education was chosen for a very particular reason. So the background in this case is that the state of Oklahoma had two different minimum drinking ages. Women could buy beer at the age of 18. Men had to wait until they were 21. So the group looking to end gender-based, or at least significantly lessen gender-based distinctions in the law, took a case in which men were the ones being discriminated against. This was strategic, and this was very smart. So the question in this case is whether this law, which makes a distinction in gender, is a violation of the Equal Protection Clause. Well, let me take a diatribe a little bit. So this is about what beer can be bought in Oklahoma. And allow me to weigh in and say, at least in the 1970s, what they were buying wasn't beer by anyone's standard, or by any reasonable person's standard. Beer was capped in the states of Oklahoma and Utah at 3.2% alcohol. That's not beer. That's near beer. That's water with coloring. I'm not certain, but that's what we're talking about. The states of Oklahoma and Utah are, though less now, extremely conservative with regards to alcohol sales and alcohol consumption. So understand that the states can regulate in this area, very much like Gossett v. Clary. So the states were given a large degree of leeway. So the question is whether that leeway comes down to this gender-based distinction. And the answer is, the court says, no, there's simply no good reason for this distinction in the law. And the court compromises. So the majority weighs in that, well, strict scrutiny is too high a standard for gender-based distinctions and gender discrimination, primarily because numerical minority status is not a thing. However, there is overwhelmingly a history of gender-based discrimination, and so rational basis isn't enough. Strict scrutiny is too high, rational basis is too low. So the court, quote, develops a heightened intermediate level of scrutiny. We generally refer to this as intermediate scrutiny. Some folks refer to it as heightened scrutiny. But in essence, if you think of the bookends of rational basis and strict scrutiny, intermediate scrutiny is, as it sounds, somewhere in the middle. They issue a new test. And using this new test, they held that a gender-based classification that does not serve an important government interest and one that is not substantially related to achieving that important government interest must be a violation of the 14th Amendment Equal Protection Clause. And in this case, that was very clear, that there certainly was an important government interest in this case, and we'll get to that in a second because of Oklahoma's argument. But the method by which they regulated was not closely related to that important governmental interest. So what did Oklahoma say was the important governmental interest in this case? Well, Oklahoma argued that men had higher rates of drunk driving than women of comparable age. That was true, but it was not substantial. So in quantitative studies, we have two different words we like to use when we talk about whether there's an effect in the data. We will say that there's a statistically significant effect. And in this case, that statistically significant effect is that, yes, men had much higher rates of drunk driving than women of comparable age. In fact, 10 times or 11 times more men aged 18 to 20 were arrested for DWI than women of the same age. 11 times. That sounds like a lot. But 11 times likely to get a DWI is based upon a very, very, very small number. So there were 11 times more men than women that were arrested for DWI. But the number was so minuscule, number of women per 1,000 that were arrested for this law, that when you multiply it by 11 times, the ultimate number that you get to is still amazingly low. And so that while there was a statistically significant effect, there were more men who were engaging in this behavior than women, the substantive effect, so how much it actually occurred difference, was negligible. And Brennan points this out in his majority opinion. He's like, yes, it is 11 times, but 11 times 0.3 isn't a huge number. It's certainly 11 times bigger, but it's not substantial. And therefore the law, which set this bright line distinction between men and women, was not related to the important governmental purpose. And absolutely it was an important governmental purpose. Drunk driving during this era was very much an issue for all states, and therefore many states were passing laws regarding DWIs. But the relationship between the distinction between alcohol consumption and drunk driving from the ages of 18 to 20 was simply not substantial enough within the data. So while there was an important government objective, precluding all men from 18 to 20 from purchasing beer was not sufficiently related to that objective, because a wide number of men 18 to 20 who bought beer were not going to go driving after they did so. Also, Brennan says very clearly in the opinion, insofar as Gossert v. Clary may be inconsistent, that decision is disapproved. So they don't strike down Gossert v. Clary. It's not overruled, but they do distinguish it into basically the ether. They don't overturn it in its entirety, but they put it in a place where Gossert v. Clary is no longer good law. But they don't overrule it. Now, Justice Brennan writes the decision. Remember that Justice Brennan is one of the individuals who pushed for strict scrutiny in Fontiero. He didn't change his mind. Let's not assume that at all. The 3 years have gone by. It's not as though Justice Brennan changed his mind. He still wanted strict scrutiny as the standard. So why is it not the standard? And it's not the standard because he simply knew he could not get a majority of the court to sign on to strict scrutiny. But he could get a majority to sign on to something different. A majority of the court could agree that rational basis was too low. So Brennan accepted this idea of intermediate scrutiny, even though he preferred strict scrutiny better. Which is to say that Justice Brennan simply was strategic. Justice Brennan has been known, and we've heard from stories of his clerks, that he very often, when clerks were first hired, he would ask them, what is the most important word on the Supreme Court? And to answer, once they stumbled around and said things like equal rights or the 14th Amendment or the First Amendment, he would hold up his hand and just do this. And he would go, 5. 5 is the most important word on the United States Supreme Court because you can't get anything done without 5 justices agreeing. And so in this case, Brennan modified what it is that he wanted in order to get that majority. So he compromises what he truly desires to get something that's better than what already existed. So there were a couple of dissents in this case. Rehnquist and Chief Justice Burger, who, if you remember, was in the majority of the previous case, they both are in dissent here. And the reason why Chief Justice Burger joins in dissent is that they disagree with intermediate scrutiny. Both of them argue that the rational basis test is sufficient and that under that test, the rational basis test, this law survives and would simply be constitutional. In fact, Rehnquist goes so far as to say that the only redeeming feature of the court's opinion, to my mind, is that it apparently signals a retreat from those who joined the plurality opinion in Fontiero for their view that sex is a suspect classification for the purposes of equal protection analysis. So Rehnquist says that, look, I don't agree with heightened scrutiny, but the best thing about this opinion is that there's no one arguing that it should be strict scrutiny anymore. So Justice Rehnquist, very much against this notion of heightened scrutiny, would very much want it to be rational basis. Keep an eye on Justice Rehnquist. Justice Rehnquist ultimately becomes Chief Justice Rehnquist, and also ultimately becomes a Chief Justice with 2 women working underneath him. Justice Ruth Bader Ginsburg, when she ultimately joins the court, and Justice Sandra Day O'Connor. Some part of that may have affected how Justice Rehnquist decides cases with gender-based distinctions in the future. But understand that in 1976, with no other women on the court, he was very much against the raising of any standard in terms of gender-based distinctions and thought that rational basis should absolutely apply in every case in which there was a gender or sex-based distinction.